Welcome back to the Law News Network. I'm your host this afternoon, Caroline Polisi, and we have a very special segment for our viewers today. Things are heating up in the Robert Mueller Russia investigation, and all eyes are now on Michael Flynn and Michael Flynn Jr., his son. Word is that Mueller and his team are homing in to bring charges imminently against Flynn or Flynn Jr. I'm joined today with a very special guest, Eric Creizman.
Thank you.
Federal and white-collar criminal defense attorney. Now, Eric, I could think of nobody better to be on the show with me than you today, because I know from experience that you defend against these types of charges, specifically the charges that we saw in the Manafort and Gates indictment and the ones that potentially we could be expecting in the Flynn indictment, every single day in your job as a white-collar criminal defense attorney, because we've tried a bunch of cases together.
We have.
Right?
We have.
Right?
And I could think of no show better to appear on than this one.
Great.
In fact, just so I don't feel out of place, I didn't have a MacBook, but I do have an iPad Pro.
Okay, great.
So, you know.
Great, you'll fit right in.
I'm
fabulous,
fitting in.
Fabulous.
Okay.
So, Eric, I want to talk a little bit about, of course, the rumor mill is churning. We don't know for sure yet, but the word on the street is that Mueller is using this leverage of the Flynn Jr. issue to really flip former disgraced national security advisor to President Trump, Michael Flynn Sr. Is that typical in sort of the way the DOJ operates? Do United States attorneys typically pit, family members against one another?
Actually, in two of the cases that we have tried together, there has been that particular situation. There's, they'll threaten to arrest someone's wife.
Yep.
Or I've seen a situation where the FBI raided someone's house and said, look, we're going to arrest you, we're going to arrest your wife, and we're going to arrest your father. This was a healthcare fraud. And and basically we have a social worker right here to take the person into social services if you don't start cooperating right now.
Right.
That's an extreme example, but it's happened.
Well, I think it's funny. A lot of people are saying,
often.
Yeah, a lot of people are sort of, on talk shows saying, wow, this is hardball. But it is hardball, but we see it every day, and it's not something that they're above. And it's a common tactic that they use.
If they can charge, if they have a legitimate basis to charge the son, which it seems that they might, then sure. I don't think they're obviously as interested in the son as they are the father, but that's how it works, right? The father has to. That's his weak spot.
Right. And so just for our viewers to know, apparently, according to two witnesses who have already been interviewed by Mueller and his team, they spoke with CNN saying that they were asking questions about Flynn's business dealings overseas. Of course, we know about this FAR, the Foreign Agents Registration Act, requires those who do business or acts of foreign companies or government to publicly disclose that relationship. And the word is that the Flynns may not have done so. The consulting and lobbying work that both of the Flynns did for their family business, the Flynn Intel Group. Of course, Flynn Jr. accompanied his father overseas for that famous trip to Moscow in 2015, where we have that photograph of Flynn Sr. sitting next to Putin. Again, it's not clear that either of the Flynns will be indicted. They could be cooperating. I mean,
did you see about there's now discussion about Turkish lobbying for the Turkish government and not registering here.
Exactly.
And one of the issues was Flynn and Flynn's son and their firm were going to be paid to lobby to release basically this fellow Reza Zarrab, who's actually in the there's a criminal case in the Southern District of New York and in front of Judge Berman. And it should be, we know that Reza Zarrab has hired during the entirety of his case, he ended up hiring Mukasey, former Judge Mukasey, and Rudy Giuliani. So this makes things more interesting. And the role that they were supposed to play was to try to work something out with the Turkish government in order to see if there was some way that this case could be settled.
Giuliani?
Giuliani.
Wow, interesting.
Yeah.
I hadn't heard that.
Yes, that's what Judge Berman asked. Well, I'm sorry, Zarab was represented by Ben Brafman, and all of a sudden,
who, by the way, is representing Harvey Weinstein.
That's right.
Ben
I
Brafman.
did. I
Yep.
saw that. That's
Yeah.
exactly right. But that was your last guess, no? So Mukasey, the former Judge Mukasey in the Southern District, and Giuliani were both hired. And when Judge Berman asked, what is your role in all of this? They said their role is to try to work something out with the Turkish government. If I'm not mistaken, yeah.
Wow.
And that was well before this all happened.
Very
well
interesting.
before this all came to light.
Well, funny you should mention that, because I did want to point out that both Manafort and Flynn had been investigated, the subject of DOJ investigations, prior to Mueller being appointed in May of this year. So the question that raises is, everybody's sort of marveling at the speed at which Mueller and his team indicted Manafort and Gates and got this guilty plea out of Papadopoulos. What that says to me is that sort of they picked up where the DOJ left off, or
Right.
where another office left off. Do you think that they're working collaboratively with other offices?
Yes, of
Okay.
course. I think they are.
And how does that happen? So you think that sort of the AUSAs and the SDNY are providing information?
They
whatever
share
they
information. I'm sure they share information.
Interesting.
I would imagine they share information. That's what law enforcement agencies do all the time,
Right.
in terms of investigating a case. So it would make sense that that's happening here.
Interesting. Speaking of Manafort and Gates, those two indictments came down the same day that we got a guilty plea from George Papadopoulos. Everybody was expecting the indictments of Manafort and Gates, or Manafort at least, but nobody knew who this guy Papadopoulos was before that day. What does it tell you? The nature of the charge, the nature of the guilty plea, what does that tell you about this investigation?
The Papadopoulos case is actually more connected, in my mind, to the Trump campaign than the Manafort and Gates indictment.
Yep.
The Manafort and Gates indictment seemed to me to be focused on wrongdoing that Manafort and Gates had done for years before the Trump campaign. With Papadopoulos, this basically addresses conduct that occurred directly while he was on the campaign staff. So, there was a meeting that was organized, apparently, which he lied to the FBI about. He hid, and that's the crime here, that he lied to the FBI. When they asked him questions, he decided not to tell the truth.
I think that's so important to point out to our viewers, that the conduct alleged in this guilty plea in and of itself, in terms of the contact with Russian officials, with this professor, London-based professor, that in and of itself, that conduct is not criminal, or it's not alleged at this time to be criminal. What was the criminality here?
The criminality here was lying to
That's
a
right.
federal agent.
Right.
And you can't do that.
The 1001 charge.
That's a 1001 charge. And Martha Stewart
Yep.
was prosecuted for the same thing. The interesting thing here, what they're trying to do perhaps, is use him. He may have information about meetings and the intentions of the Trump campaign, and what they wanted from Russia and what Russia wanted from them. And there could be a number of potential charges that they might be investigating. If there was a donation to the Trump campaign, that would violate campaign finance laws. If there was, there's a whole bunch. There was also Jared Kushner, when he filed for security clearance. Mm-hmm. He did not disclose that he met with any Russian officials, and then he later changed that. That's actually a 1001
Yep.
technically, if they could prove that he knowingly and intentionally did that. If he knowingly and intentionally lied
on his FS-86 form. I know
that's right.
And I think that the message that Mueller is sending here to everyone with this Papadopoulos guilty plea is that we will charge 1001. If you come in and lie to us, we are going to prosecute that to the fullest extent that we can. So don't lie to us. I think
Right.
a lot of people may be amending sort of their testimony that they've given to Mueller and his team if they perhaps forgot something along the way, because they could be prosecuted for it.
Well, amending, though, doesn't really help you. At this point, meaning you know, if you really didn't remember something, then you
Right.
didn't remember something, then you're okay. But amending it is all, I mean, I think it's very shaky for someone who had this meeting with a Russian attorney. And I believe that Jared Kushner was part of that meeting.
Natalia Veselnitskaya.
That's
Yes.
correct.
Okay.
And for him not to put it down, that seems to me to be, I mean, maybe it's just because right now this is taking center stage,
Right.
and people didn't think about it at the time, but to me it's kind of surprising that someone would forget that this
Right.
is and if you legitimately forgot, it, you know, it's not a violation of 1001.
Right.
If you legitimately didn't remember, and the government would have to prove that he intentionally lied. So
Right.
that's the difficulty. Here Papadopoulos gave these people, you know, a case. I mean, he gave them, the FBI agents showed up at his door hoping he would talk.
Right.
So that they, boom, nailed him.
Right,
now
right,
they
right.
have this guy, and who knows what he can give them.
Right.
Who knows?
Do you think he was wearing a wire? We know he's been cooperating for at least the past 3 months. This guilty plea, remember, this was under seal, so this was way back in the summer, and a lot of people are speculating that Papadopoulos may have been wearing a wire as recently as last month.
He could have been making phone calls, sure.
Right.
I mean, consensually recorded calls. Yes,
Right.
it's all possible.
I think they use the term proactive cooperation.
They do.
What does that signal to you?
That signals that when someone, I mean, before there's, the conviction or the guilty plea is revealed for a cooperator, someone might be acting at the behest of the government. It's sealed. The whole case is sealed. It was a John Doe case.
Right.
And you know, if you looked on the federal court case lookup system called PACER, you wouldn't find it. And during that time period, the government might have him going out and trying to elicit incriminating statements from whoever they think they might be able to.
Yeah. So I want to get into sort of the mindset here of how you counsel your clients, because we have represented clients that go in to talk to the Department of Justice. They're either targets, subjects of an investigation. You're never really quite sure. But how do you prepare those witnesses to go in and talk to United States attorneys?
Well, I generally don't bring them in to talk to United States attorneys. And I think it's a very dangerous, I think it's dangerous to bring in a client to talk to a government, to prosecutors. And what I often tell clients is that, you know, what the government can do with your statements, if a client is going to say something, that's going to be used against them. There's some sort of limited protections that are given, but it's very limited, and the exceptions are quite broad.
Talk about that. Queen for a day?
Yes, queen for a day. It's basically they say, look, anything you say in this meeting, we can't use to prosecute you. So if you come in and say, I stole a car and I've hid it behind in my backyard under a tarp, right? They can't later on prosecute you and say, and use in proving the case. They can't say, hey, this guy came in and said to us that what he did, right? But they could use leads from the conversation, so they could have, they could go to a judge. Is that like a?
Yeah, sorry.
Okay. So they could have a judge issue a search warrant based on what this person said, and so you could go to the person's house, find the car, find the tarp. Okay, that's pretty damaging. You could also, if the defendant decides to testify, and he testifies in a way that's contradictory to what he said at the meeting, they can call the agent, and the agent will say, hey, this person came in and testified, TARP and so on. And even if the lawyer makes an argument and it's contradictory, the government can bring someone in. The agent in. So it's very dangerous to bring a client in to talk to the government. And the only times I really might ever do that is if the client has a lot to gain and very little to lose. And I have to be sure also that the client has something worth offering to the government in a cooperation sort of sense.
Speaking of cooperating with the government, that's of course what everybody's talking about. Everybody assuming that Papadopoulos took this guilty plea in exchange for cooperation.
I think it's actually explicitly in the plea agreement.
So talk about what substantial cooperation means. Tell me about a 5K1 letter. Tell me about how that works at sentencing for the defendant that cooperates.
Okay, so right now, I mean, assuming that he is cooperating, which I think he is, this looks kind of like a cooperation agreement we'd get. Not exactly, but the general idea is that in order to get a cooperation credit, in order for the government to ask the judge for leniency at your sentencing for pleading guilty to this, the person's got to meet with the government as much as the government asks, provide information and documents, and be truthful at all times, and testify where the government wants him to testify. He's basically working for the government at this point. And the government has to be satisfied that he was truthful and that he provided substantial assistance. Sometimes they might find that a cooperator has been truthful, but he didn't provide substantial assistance. He really didn't have anything to give him. And so that's another reason why not to bring in a client to talk to prosecutors. Often, if you're thinking about it, you have to go in and see if the prosecutor, maybe the lawyer will go in, and something I've done before, and talk to prosecutors and say, look, this is what I think he'll say. That can't be used against my client. So to see if they're going to buy what he has to say, and then talk about in broad strokes perhaps where he can be cooperative, and then see if there's really any, because if they say we don't believe the story, then the client's not going in. Right.
So I love about you, Eric, I love practicing with you because we sort of wore the fact that neither of us were former prosecutors with a badge of honor, right? We're not just kowtowing to the government. We're not going to just bring our client in to make a deal. And a lot of times, United States attorneys were kind of shocked with that statement. You know, I mean, they're used to having sort of former members of that team who have then gone into the field of criminal defense.
As they call it often, private practice.
Private practice,
right.
they call it.
Right,
yes.
Which is something that's the difference between a defense lawyer and a former prosecutor.
Yes.
Private practice is the term they use.
I like it. Well, speaking of which, you know, they executed a no-knock warrant on Manafort's home.
Right.
And people were kind of surprised about that. I was not surprised. Were you surprised?
I don't know. No, not really. I don't know.
I mean, my point
why
is,
is there a no-knock warrant? Meaning what? That you don't knock? I'm not really sure.
They knocked down his door.
They knocked down his door?
Well,
yes, I'm a little surprised. I mean, did they think that he had guns in there? No. I mean, what's the...
Well, traditionally, I think traditionally that has been the argument for why the government has treated sort of white-collar criminals. They afford them a level of civility that they don't afford violent criminal defendants.
But there's a reason, which is that you just said it, violent.
Right.
So, I mean, but often when white-collar criminals are arrested in their homes, they might knock at the door, but there's a large contingent of law enforcement, FBI agents, local police officers. The force, this show of force is overwhelming, so that there's not even an idea that anyone's going to resist. But a no-knock warrant, I'm not sure. I mean, does that mean that they're authorized, that they they just knocked down the guy's door, or what? I actually don't know what that honestly means.
Well,
I mean, but if that means that that's what they did, or did they actually knock at his door and he answered it and he was arrested, then that's okay with me. And if he didn't, then they have the right to just knock it down. That's fine too.
So take us behind the scenes of what's happening now. Manafort and Gates, their trial date has been set next year. What happens now? What's going on?
I think that they're probably going through the discovery. The government's obligated to turn over certain items in discovery.
You think that's been turned over?
I think some of it. I think some things have been turned over. This is probably going to be somewhat complicated by the national security nature of the materials that are being produced, but ultimately there are protective orders in place so that people can't just release the discovery to the public or to anyone else other than potential witnesses, and you can't let them keep it and so on. And there's probably the defense is considering motion practice at this point.
So we have the indictments here in front of us. Pretty intense indictment here. We, in our line of work, we see a lot of different types of indictment. People have been referring to this one as a speaking indictment. I mean, you have here.
You get that a lot in the Southern District of New York, especially. They're, as you would say, notorious for speaking indictments, basically telling the entire story. And I think it's important for the special counsel to tell a story here because the public's watching this.
Right.
This is critical, and it justifies what they are doing. So they have a speaking indictment so the public understands what's going on. They don't need all this detail,
right,
but they have it. Now,
so of course the question is, now you're talking about pre-trial motions. Do you even see a bill of particulars in this indictment? You don't really need much more than here, do you?
That's right, although, there's always, yeah, and this one, this is quite
pretty laid out.
This is quite detailed, but there's
that's
other motions
basically all of the
besides the bill of
discovery right there. If we can show on our screen here, I mean, they have each and every bank transfer here. I mean, there are pages upon pages with the actual dollar amounts here in the allegations of money laundering, and that's not always typical in indictments for these types of crimes. Am I right, Eric?
Yeah, that's right, and they identify the false statements.
Right.
So there's a lot of detail in this indictment, but there's other, I mean, who knows what kind of potential motions could be made, but in general, severance, I don't think that would be something that makes any sense here.
Right.
But there are pretrial motions that can be made, and then after pretrial motions are decided, there may be, there's people get ready for trial. They start to put in evidentiary motions, what the government can introduce, what the government can't introduce, and vice versa.
Right, right. Well, you mentioned severance. Of course, this is an indictment with both Manafort and Gates on it. So I think Eric was alluding to maybe making a motion to have two different trials. Oftentimes, the government will proceed with indictment like this and have a multi-defendant trial.
Trials is spelled with an S at the end,
right?
Unlike news, which is
right.
spelled with a Z.
Right. Very, 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 very good point there.
Thank you.
So just switching gears a little bit here, Michael Flynn Jr., again, who is rumored to sort of be in the crosshairs of this investigation, he actually tweeted recently, and I want to see if we can put that tweet up. Yep, okay. The SJW, and I believe that stands for Social Justice Warriors, are out in full this morning. The disappointment on your faces when I don't go to jail will be worth all of your harassment. Now, Eric, if you're this guy's lawyer, what do you tell him?
I mean, I would tell him not to do that. I don't think he gets anywhere by doing that.
Right.
But I don't think that ultimately, I don't think that that's going to come back and hurt him. But I mean,
do you think Mueller is on Twitter reading that tweet right now?
I'm sure he knows about it.
Okay.
Yes.
And you think that's going to sort of make him double down?
No, I don't think so.
Okay, I agree with you. I think
that. Oh, hi. No, I think that that's absolutely, I wouldn't advise my client to make public statements like this.
Okay.
In this situation, maybe it's not the absolute worst statement that one could make, but it's not wise.
Okay. Well, it reminds me, remember, of the Don Jr. tweet. Remember when all this stuff came about, the Trump Tower meeting with Natalia Veselinskaya, and he sort of got ahead. The Times was going to publish the emails, and he made that tweet sort of saying that in the spirit of full transparency, he released all of those emails over Twitter. Now, at the time, he was represented by someone we know, a colleague of ours, Alan Futerfas. Mm-hmm. What do you think Alan was telling Don Jr. at the time?
Are you saying that Don Jr. released the...
Correct.
emails?
He did over Twitter.
I don't know.
Yeah.
I have no idea.
Okay.
I wasn't there. I mean, I know him.
Do you have clients that sort of want to take to social media and defend themselves? I mean, you have high-profile clients.
Yes, I do.
Yeah.
And yeah, there are. I actually had a client who was quite a high profile, and we came back from court one day only to find two members of the press right in the office with us, right in our conference room, which he called the impromptu press conference. And I said, look, this is really not appropriate, client.
Right.
And we don't need that. That's not going to be helpful right now.
Interesting.
Right.
Interesting. We don't have much time left, Eric, but
no.
where do you see the Mueller investigation going? I mean, a lot of people are saying this is, the Trump sort of party line is this is the beginning of the end, but I think everybody else thinks it's sort of just the end of the beginning, meaning there's a lot more that's going to happen here. What do you see on the horizon?
It would be interesting to see, I think, what happens with, I mean, look, I don't know how Manafort became Trump's campaign manager.
Right.
That's a big issue.
Right.
Papadopoulos, all of these contacts with the Russians, that doesn't look so good,
right.
Ultimately. So, I mean, who knows? I don't think it's the beginning of the end. I don't think that this shows nothing, absolutely.
Right.
Who knows? I mean, it doesn't necessarily show anything against Trump, but who knows?
Right, right. Eric, always a pleasure to have you on.
No, it's wonderful.
Thank
Honestly,
you so much.
This network, one thing about this network, it has the best live feed of the Supreme Court people going back and forth and back and forth.
Maybe we'll see you on there
What's
sometime.
that?
We'll see you there. Thank you so much for joining us, Eric.
It's been wonderful.
And when we come back, Aaron Keller is going to be here with some special segments of his own. Until that time, we're going to catch you up in the Adam Matos trial, taking you back to some previous testimony there.
Don't miss